Have a seat. We have tried to contact Mr. Aronson's office, and he, according to his assistant there, did not get notice, although notice was sent to the email address he provided. Ms. Moses, since you asked for the oral argument, we'll give you 10 minutes but let me set my clock in. So whenever you are ready.
All right, thank you, Judge Berger. It is my practice to request oral argument when I'm not the appellant because I don't get the last word, so I traditionally request it to make sure I can clear anything up. Thank you for going ahead, though, because I have brought with me two law students, Melissa Hernandez from Barry and Amanda Green from FAMU, and they're my mentees and wanted to watch something like this, so at least they're going to get 10 minutes worth of watching it, so thank you very much. I am here today representing John BENEZETTE and the law firm of John BENEZETTE. We are asking the court to affirm the final judgment below. We believe that the trial court was correct in granting summary final judgment in favor of the defendant because the plaintiff could not prove a negligent act. The only thing they could prove is the hiring of Mr. BENEZETTE as the lawyer, but they could not prove a negligent act on Mr. BENEZETTE's part nor a causal connection to any alleged injury. Briefly, yes, sir.
Moses, let me ask you this. The email that Mr. COMINSE sends to Mr. BENEZETTE October 1st, and I think the settlement was 10 days or so later, he's very specific in there that says, I'll settle the comp claim for X, which he got, but I still want John to check the laws, and I wish to pursue the wrongful termination lawsuit as discussed. So he's pretty clear, at least in that email, that the wrongful termination suit's still on his radar. His claim, if I understand it from the depots, is that when he comes into Mr. BENEZETTE's office 10 days or so hence, that the paralegal did not explain to him that he was waiving his right to bring that claim. She says that she did, so we've got a factual dispute there, and I think we agree if that's all we had, we'd be off to the races. We've got an additional affidavit from, I forget the fellow's name, but he says, I was the operations manager at the Daytona branch for about 6 years, beginning in 2005, which is, and I think COMINSE started in 1999. So he comes in kind of in the middle of COMINSE's employment. He says, I was aware of COMINSE's criminal issues and his probation status, and I discussed it specifically with the regional manager. Is that level of knowledge at the corporate level sufficient to impute that knowledge to the corporation to create at least an inference that the corporation was aware of COMINSE's criminal history and for 5 or 6 years and took no action until they canned him as a result of the comp claim?
Well, I don't think they canned him as a result of the comp claim. Mr. Cohen testified...
Well, that's his contention.
That's his contention. But Mr. Cohen testified that the only reason that he was let go was because during the work comp claim, the service, entity that services the claims discovered that he had this criminal background and provided it to Mr. Cohen, and he testified that for the very first time, he became aware of it, and in his position, as the first time he ever became aware of it, not only was Mr. COMINSE terminated for having this background, but for falsifying his application. I do not...
Indulge me in a hypothetical.
Yes, sir.
So I take it that Mr. Cohen is like the HR director or something along those lines. So let's assume that the person who occupied Mr. Cohen's slot before Cohen gets there knew about this and was okay with it. But the company said, we're fine the fact that you're on probation for this sort of crime. But now Cohen doesn't. And Cohen looks at that and says, well, if I had known this, I would have canned the guy. I would have never hired him. does the corporation waive it if the decision makers have the knowledge and choose not to act on it, and then simply because they've changed decision makers, the new decision maker comes in and says, well, I don't like that decision, you're out?
Okay, well, concede with me that that's a complete hypothetical, because that is not the facts in this case.
That's why I called it a hypothetical.
Yes. There is no proof that anyone in Mr. Cohen's position knew of A, the criminal background, and B, the falsified application. In fact, he asked to see the application and have it checked to see if it was disclosed, I think because maybe Mr. Cohen might be working along your hypothetical as maybe the person before me knew this. Let's see what's on the application. But once he saw that the application did not disclose this, it was done. Not only does he have the background, but he falsified his application. I believe I brought to the court's attention I'm forgetting the name of the decision right now, where the rest of all the lower level employee, the school board case, where the school board, someone who hired the gentleman knew about their background, and he said, that's fine, don't worry about it. And the higher up said, no, that's not your role to play in this, to decide whether someone with such a background like this can work here, and we're not going to impute that to the school board. Therefore, they found that it was a legitimate reason for terminating that employee, and that it was not merely a pretext. And that was the argument in this case. The legitimate reason for terminating Mr. COMINSE was the fact that he had the criminal background, plus he lied on his application. Therefore, the argument is he didn't have a winnable wrongful termination case anyway, such that even if what Mr. Benezette did was negligent, it did not result in an injury to Mr. COMINSE, because he didn't have a wrongful termination claim. He had to establish a prima facie case that there was conduct, that there was an adverse reaction to it, and that those two were causally related. It's our contention that he didn't even make his prima facie case, but if he did, then you get to the employer has the burden to prove that they had a legitimate reason for terminating him, which they did. Mr. Cohen stated, once I found out about this, it was over. He's got the background in a falsified application, period. And he said, this is the first time I knew it. COMINSE did not offer anything to prove that was a pretext. What is being offered as the pretext is the fact that Mr. Cohen couldn't explain why a criminal background check is done in a workers' comp claim. He said, honestly, I don't know why, but it was done, and as a result, I, for the first time, got this information and made the decision to terminate him. So a pretext for the firing was never proven by Mr. COMINSE. So it's our position that even if Mr. Benezette had acted negligently, which we don't believe he did, there was not damage to Mr. COMINSE because he did not have the wrongful termination claim that he believed he did. With respect to the workers' comp claim, I think we were fairly clear in our brief. The only opinion that the injury was related to the job was from a non-authorized treating physician. That's not admissible in the JCC. He could not be certified as an IME, Dr. Rasmussen, because he was rejected by the employer. The suggestion that his name on the employer carrier's IME list constitutes a waiver, even their own expert said, no, the workers' compensation laws don't provide for that. I don't know what a judge would do. It would be a contract issue. But he couldn't say in his deposition that there was authority for the argument that Mr. COMINSE is now putting forth, that somehow Mr. Rasmussen, Dr. Rasmussen, should have been an IME doctor. And then finally, Mr. Benezette could not have requested that an expert medical advisor be appointed because there wasn't a conflict in the only admissible evidence. The only admissible evidence was two IMEs saying it wasn't work-related. There's no authority under 440.13.9 for an expert medical advisor to be appointed. Therefore, Mr. Benezette did not do anything wrong in not seeking the appointment of an expert medical advisor. Therefore, it's our contention that Mr. Cominse's workers' comp claim was resolved voluntarily through settlement at a value he agreed to. I hope it was not lost on the court in my brief, where I do mention that Mr. Cominse actually requested specific changes be made in the settlement documents. The suggestion that he did not read them or understand them is simply wrong. He's not happy with the outcome, but the fact that he could go so far as to have language stricken because he was concerned how it would affect his disability benefits shows that he clearly knew what he was signing and what he was doing. And then, of course, our second argument is he did not have a wrongful termination claim that was viable at all. Therefore, the settlement of that claim did not result in damage to Mr. Benezette. So we would request that you, or to Mr. Cominse, we would request that you affirm the final judgment below in favor of appellee John Benezette and the law offices of John Benezette.
So just to revisit the wrongful termination aspect of your argument, your support for the fact that the presence of the affidavit by the local operations manager did not create a material issue, a genuine issue of material fact, that's based upon the Silvera 11th Circuit case, is that correct?
Yeah, I'm beyond my time, may I answer?
You may.
Yes, it's based on Silvera, and the fact that everybody that said they knew about it did not go beyond themselves. So they never sent the information up to the decision makers. So there is not a disputed issue of fact with respect to Mr. Cohen's knowledge or anyone above the regional level.
Okay.
Okay?
All right, thank you.
Thank you.